Hi everyone, this is Samidha Hegde. I'm interning with LEXIS and Company. I'm a third year law student studying in Ramya College of Law, Bangalore. And today I'm going to be discussing about types of company under Companies Act 2013. So under types we have several types and subtypes under those. So we'll be going on one by one. So first, based on incorporation. Based on incorporation, we have three types of companies: that is chartered companies, statutory companies, and registered companies. Chartered companies are those that used to exist at during the time of kings and queens. For example, East India Company, Bank of Japan, all those companies existed during those times, during the times of kings and queens, and these companies no longer exist. And so in today's world, they are irrelevant. So next we have statutory companies. Statutory companies are those which derive their authority from a statute. Example would be LIC. Then we have registered companies. Registered companies are those companies which are registered either under Companies Act 2013 or any previous law regarding companies, any previous companies law. For example, Companies Act 1956, if they were registered under Companies Act 1956. So these are the types of companies based on incorporation. Next we have companies based on their liability. Now based on liability, we have unlimited liability company and limited liability company. So first let's talk about unlimited liability company. Unlimited liability companies are those in which the liabilities of the members are unlimited. That means they are completely responsible for all the debts and obligations of the company. And if suppose, let's say, at the time of winding up, or maybe during insolvency or any such situation, if the members may have to, if the company has debts that are uncleared, then the members will also need to clear it from their personal assets, from their personal properties, and using that they will have to clear it because they hold unlimited liability. Now next we have limited liability companies. Under limited liability companies we have company limited by guarantee and company limited by shares. So here, as it is evident that the liability of the members are limited in both of these cases. Under company limited by liability, company limited by liability of shares, limited liability of shares, in that members hold limited liability through memorandum of association. They have limited their liability, and their liability is limited to the number of shares held by them, to the number of unpaid shares held by them. So whatever unpaid shares are there, once they pay up the share capital for the unpaid shares, then their liability comes to an end. Then we have company limited by guarantee. It is the same as company limited by shares, except here they have undertaken limited guarantee and not shares. Here also, through memorandum of association, they have limited their liability. Here the members act as guarantors of the company for its debts and obligations, but they have a limited liability. That means they are only responsible for the up to the extent that they have taken up the liability. Examples of this would be clubs, trade associations are examples of company limited by guarantee. So these are types of companies based on liability. Next we have company based on the number of its members. Under this we have first one-person company. As the name itself suggests, one-person company has only one person, only one shareholder. He is the sole member of the company, and this did not exist earlier, and it was actually introduced in Companies Act 2013 only. Earlier, one person company was not recognized. And one person company is different from sole proprietorship because there the business and person are treated as same entity, but here, since in one person company, the company has a separate legal existence and it is incorporated, and that is why it is different from sole proprietorship. And one of the unique features of one person company is that here the member is required to appoint a nominee at the time of registration. Why? Because company has perpetual succession, as you know, and if the sole member of the company dies, then who will be responsible for the company? Who will be the sole member of the company? That is why a nominee is appointed at the time of registration. So after this we have private companies. Private companies are restrictive in nature, um, in the sense that here there cannot be transfer of shares easily. The members are not allowed to transfer shares. Public cannot be invited to subscribe to debentures and shares, and also private companies can only have maximum of 200 members, and a minimum of 2 directors are necessary in private companies. And private companies stand out because um, the suffix of the company name, that is at the end of the name, private limited is written, so that distinguishes private companies. Next we have public companies. In the shares and debentures can be easily transferred. Public may be invited to subscribe to shares and debentures, and in public company, minimum of to register a public company there must be a minimum of 7 members, and these companies are capable of being listed by recognized stock exchange. So these are the types of companies based on the number of members. Next we have companies based on control or holding. In this we have first we have holding and holding and subsidiary companies, and then we'll be talking about associate companies. So holding and subsidiary companies. In this, the holding company is basically the parent company, and the subsidiary company and the parent company, that is the holding company, exercises control over this subsidiary company. It can be either by owning more than 50% of the shares in the subsidiary company, or it can be or the parent company or the holding company may have control over composition of board of directors of the subsidiary company. So this is holding and subsidiary company. Then after that, based on control or holding, we have associate companies. Associate companies are similar to that of subsidiaries, but they are not exactly subsidiaries. So in associate companies, the other company has significant influence on this associate company. It can be either through holding of shares. At least the company must hold a minimum of 20% of the shares of associate company to have significant influence over this company. um, Significant, yeah. And but remember that associate companies are not the same as subsidiary companies, but the other company who has significant influence over this associate companies may have influence over the business decisions of this associate company. So these are the types of companies based on control or holding. Next and last, we have companies based on national interest, that is Indian companies and foreign companies. Now you know this, it is very basic. Indian companies are those which are incorporated and formed in India and registered in India, and foreign companies are those which are incorporated in some other country, but they run or conduct business activities in India. For example, most of the fast food chain restaurants like Domino's, Pizza Hut, etc. are foreign companies. So yeah, these are all the types of companies. I hope you understood. all the different types of companies we have under Companies Act. And if you like the video, please like, share and subscribe to the channel and press the notification button for updates. Thank you.